Help me greet, please, from Australia, John Graham, and from Calgary, Alberta, Lorri Yasenik. A nice hand of applause, please.
Thank you.
Tell me, why did you come to Montreal?
Well, I came because the symposium was on, and
I mean the symposium about the family transition in the 21st century organized by children now?
That's the one, yeah.
What makes this symposium different to your opinion?
Well, from my point of view, the gathering of people is a very, very impressive group of thinkers. There's academics, there's researchers, and there's practitioners, which is it's just so rare. It's fantastic to be in a gathering of these people.
Tell me, how did you get together? I understand you're from Australia, you're from Calgary, and now you're working together.
Yes, we are, yes. Well, we met here in Montreal at the symposium 4 years ago. And we ended up at the very end of the roundtable discussions having the same interest in children, and we were at the children's table. So we started to talk. We started to argue a little bit about differences in our countries. And then at the end, I said to John, I think we should write something. And he said, yes, that's fine, that's good. I'll give you an email. And you think, maybe the person will email you and maybe not. And sure enough, he did. And we worked together for 1 year thereafter on Skype, like so from a distance, obviously, between our two countries. And then we ended up actually writing something that has to do with children and their inclusion in family mediation processes.
The thing that we were most keen to try to work out is how can a child's voice be brought into any family law case, even as is the theme of this symposium, even in those really high conflict cases. How can those voices be represented?
Yeah, so we ended up creating a model of inclusion. And from there, then I created a program, and then from there created a training for people who are actually wanting to meet with children in various ways. And we've been delivering that now in Australia and in Canada and US.
Could we have a little summary of what it's all about?
Sure. The main thing that we're trying to achieve is creation of the space for a child to tell us whatever they want us to know, rather than going with a script of questions or interviews or anything like that. Children, as I learnt from Lorri, tend to speak through metaphor, through play, rather than speaking like we are now. This would not be a comfortable space for a child to tell us their innermost thoughts. So by creating space for the child to tell us through play their thoughts and what are their concerns about their parents' separation, that's what the model is basically focused on.
Do you see it as a judicial matter or a social issue and social support?
The inclusion of children?
Yes.
I think it's a matter of us needing to socially view children as having the right to have a voice in matters that affect their lives. And so we don't view this as just a court-related matter. We in fact developed a program for people who are not in the court-based processes yet, those people who are doing family mediation and other alternative dispute resolution practice.
In your program, do you also include the enlarged family context, such as grandparents?
They can be if they're a part of that mediation process.
Yeah. So there's no fixed rules. What we're saying is that we need to build a contract with parents that says that the voice of their child should be brought into this process, just like they're another party to their parents' separation. And then by creating that environment of normalising the need for children to be able to say what their concerns are, we then bring it back to parents in a way that's appropriate for the level of conflict that is between the parents. So for some highly conflicted parents, the amount of information they can hear is possibly less than parents who have been able to renegotiate their future relationship more effectively.
How does it differ, the child support and family support, between Australia and Canada?
In both countries, child support tends to be defined by the number of nights a child spends with a particular parent. I think that's true in Canada, and both countries do that. Interestingly, from our perspective in terms of meeting with children, the amount of time a child spends with a particular parent may not be the biggest issue for the child. It may well be more that the child is feeling stressed about the time that they have with a particular parent because one parent is more rushed or more more energetic, or just creates a space for the child that is too time intensive. So there's too much to do. So it's not so much about the issues that parents have concerns about, like child support and family support. It's more about saying, how does this voice of this child that often just gets pushed to the side, often with the best intention of saying we want to protect the child, but these children are having no opportunity to say what's important to them.
In Australia, do you still use those terms, child support, the parent that has the custody?
No. So the concepts of custody and access in Australia, we left those behind in 1995.
Wow.
So I know there's been recent changes in Canada towards that change as well. We made that shift in 1995, 96, and then we made a further change in 2006. So we now talk about the child spending time with one parent and living with the other parent. And where there is a shared arrangement, we would say the child lives with each parent and spends time with each parent as well, and spends time with grandparents. Our family law is very focused on elevating the importance of grandparents and other members of the family to the particular children.
So grandparents have rights to be able to be involved with their grandchildren?
It's a little bit different to that. It's the child has rights to spend time with their grandparents.
I love that.
With their grandparents. And it's been a very, very important message in our Family Law Act. In the best interest parts of our Act, there would be at least 15 mentions of grandparents in that section alone.
In my province, there's enormous support to change the language. They think that language will make a very, very big difference on how people approach the idea that you do not access your children like a bank account. You spend time with them. So these term changes are going to lead social thinking changes as well, not just the languaging that we use as a professional. But even in the way in which we've adopted those things already, we are not waiting for the change.
What made the government do this transition of confrontation and litigation in a way where it's more supportive and objective towards children and family? Across
all areas of legislation, Australia is pushing the cases that would normally go to court into alternate dispute resolution, on the basis that the court system is far too expensive and inaccessible to the majority of citizens.
But didn't it first come from really a major loss, a death?
And then when you look at where did the impetus for change come from in the family law system, so for the pushing to alternate dispute resolution, there was significant deaths of women, deaths of children in Australia, where it was identified that the adversarial system was in a sense farming bad behaviour, and so people were taking desperate measures because they weren't winning at court. And so what the system has moved towards is saying we want to find the classic win-win. The real reason why alternate dispute resolution exists is to help both parents feel like they can feel equally a winner and equally, in a sense, a loser, that the losses are shared and the wins are shared. That has been a major change in terms of family safety. So one of the major changes that the Australian government did was that in 1996, it inserted into our Family Law Act a suggestion that lawyers should recommend to their clients that they should go to alternate dispute resolution. At the time, it was renamed to be primary dispute resolution, with the intention that lawyers would really take up the offer of mediation. And nothing happened. The uptake didn't occur. It took the legislative change in 2006 to say lawyers must send, or parties must attempt dispute resolution before they can go to court, for the lawyers to take it seriously. And it's an example of where the law is leading social change as against following social change. So our legislature led the change to say lawyers must do things differently. We have a problem often of parents when they want to have sole custody or they want to expel a parent in the relation, will accuse them of incest or will accuse them of physical violence or
or psychological violence. How do you deal with that in Australia?
Well, first, I think the first thing is that all allegations have to be taken seriously. And so if there is a concern that one parent is not safe for any reason, I think our system, whether we're family mediators, family counsellors, lawyers or judges, we all need to make sure that that is an allegation that is untrue. So the first position would be to say we need someone to do a thorough check to make sure that what is being alleged is not true. Now, there is some anecdotal evidence that suggests that there are increased allegations of child abuse within family law proceedings. And for every person who says it's higher, there is another person to say it's not true. So I don't know whether there is more allegations, but I think there is a view in the community that says that there is. But so what do we do? I would say first up, that child needs to be safe. Second up, the child, every opportunity needs to be taken to maintain a meaningful relationship of the child with all of the people who are important in that child's life, the other parent, their grandparents, siblings, cousins, all of those people, we need to make an effort to make sure that
How do you do that?
How do you do it?
Yeah.
Well, I think family mediation actually does that better than any other part of the family law system.
I think the same. I think we work very hard at seeing not just the parents as the people in the child's life, rather than we look at the holistic picture, especially in Alberta. We have much higher rates of shared parenting in Alberta than I would say in Australia, and surprisingly in some ways. But when we do our parenting planning, it's detail around who's in their life and who should they have access to. And the program that we develop talks even about, who are the family relationships that these children have strong ties to, and how will we support those in the parenting plan in the detail.
What happens to a parent that would make such accusation and it's founded not to be founded?
Well, I know what happens in Alberta, and usually that's not founded because there's been multiple complaints and child protection's been involved and closed their file, and the child's been interviewed in multiple ways and the family's been involved in the systems. The child protection system actually closes their door. They say there'll be no more complaints that we'll receive. If we get one more complaint, then we're dealing with you from potentially an apprehension, taking the child from one of you and giving the child to the other. And it really has come down to that in the cases that I've been involved in. So they have been responsive at that level when they know that there's nothing happening.
I think there's levels of claims being unfounded. I think it's a very, very difficult area rather than just saying, well, this is what happens in every single case. Where someone makes an allegation of physical abuse or sexual abuse, there is often an evidence trail that authorities can track. And so there'll be bruises, there'll be cuts, there'll be hospitalisation, there will be a range of photographs and history and things like that. Where the allegation is of emotional and psychological and other forms of non-overt kind of abuse, it's a very, very difficult area, because even when the Child Protection Service looks into it and says there's been no proof of that, the person who's alleging it doesn't just go away and say, oh, well, it's not happening. They hold on to a belief that their child is at risk, but the system hasn't been able to find it yet. And so it's a very, very difficult area that often will lead to even professionals being divided. And so you get lawyers on either side arguing between each other, counsellors arguing between each other, and I think it's an incredibly difficult path to navigate.
Knowing that education is the key to success, would you say that creating a social media campaign, a documentary, and everything that can come with it in order to better sensitize parents of the importance of communicating, respect, and so on would be a good way of dealing with these problems?
I think it's one way, and I think it's one good way because you get a visual, you get some, it's not just about somebody coming and giving out a brochure or a handout or something a person must read. So if you get an interchange with something, or you can see something in a kind of symbolic way, I think it goes a long way.
What would you like to see coming out of this symposium?
I would like to see us make some kind of political or public kinds of statements that we could all potentially agree to. That may be trickier, but that we could all get behind somehow. I'd like to see it in the positive frame as well. I'd like to say, what could parents or what could the system do more of? And I think we'll get farther with it.
Yeah. You know, if you think about, you know, you've gathered people from across the planet into this symposium. And so there is wisdom that's coming from Europe and Australia and from the USA, from Canada. And I would like to see that wisdom somehow being honoured and treated with the utmost respect. I also, if you put an hourly rate on every single person in the room and you say, actually, how much does it cost to have that group of people in the room? I think we owe it to each other to be good stewards of that investment and to really, argue and speak to the nuances of the points that will mean that we can make a lasting difference, so that when we come back in 4 years' time, we can be proud of what we've achieved this time.
Again, thank you so much.
Yeah.
Thank you.
Thank you.